Buenas tardes. Es un gusto aquí saludarle a usted, doctor Acosta, y conocerle por este medio. Y también saludarte aquí a Daniela. Es un gusto poder saludarte de nuevo aquí también, ya de tanto tiempo desde que trabajamos en la comisión, así que es un gusto saludarte de nuevo. Me habían pedido que hiciera mi exposición en inglés aquí por estar en la Universidad de Arizona, así que también tendré una diapositiva y toda la presentación, entonces será en inglés y trataré de hablar también de manera pausada si es posible. Okay, so hi, good afternoon. My name is Leonardo Alvarado. I'm an adjunct professor at the Arizona School of Law and also within the University School of Arizona School of Law within the Indigenous Peoples Law and Policy program there. I work as legal advisor to Professor James Anaya at the Law College, who is the Special Rapporteur on the Rights of Indigenous Peoples. So a little bit to explain just the nature of our work and of my presentation.
Do you want me to help you, or you can do it?
No, I think I can do it.
Okay.
The mandate of the Special Rapporteur consists of, the Special Rapporteur is appointed by the United Nations Human Rights Council. They appoint an independent expert, in this case Professor Anaya at the law school, to monitor and report on the situation of indigenous peoples worldwide. He communicates with governments on allegations received regarding human rights violations, conducts country visits, and prepares thematic reports on issues of common concern to indigenous peoples worldwide. Within that work, within our rapporteurship, or within the support team, or rapporteurship like we call it, we have also provided technical assistance to governments who have requested it on advice on whether a particular legal draft or bill or constitutional reform process complies with indigenous rights. In fact, the Special Rapporteur, one of his earlier projects, so to speak, and this was before I started working with him, was actually working with the constitutional reform within the constitutional reform process in Ecuador in 2008, which led to the important constitutional reform in that country, which has one of the most advanced constitutional provisions, protections, not just for human rights, but indigenous rights and rights of the environment, like Daniela Salazar just pointed out. And also wanted to point out that the issue of indigenous peoples' involuntary isolation or in initial contact has not been brought up too much in terms of the cases that we have received. We have received information on in Peru with regards to the Camisea project, a natural gas project that's been going on for 2 to 3 decades, and its effects on the rights of indigenous peoples there. And the particular, as you can see from Daniela's presentation, there's going to be particular concerns to the issues of indigenous peoples' involuntary isolation in terms of the standards that apply. And my presentation deals with standards in general, but as even it's recognized in the rapporteur's last report, you're going to have to give special consideration, or they might not apply in some cases all the time to the situation of these particular peoples. But I will focus on those standards anyway. Going back to the work of the rapporteur, a major issue that has been brought to our attention within the individual complaints that we have received and the country visits that have been done has to do with the issue of extractive industries on or around indigenous peoples' territories, and has been a major source of conflicts not just in Latin America but in other regions as well, Africa, Asia, and including North America. And what I mean when I talk about extractive industries, I also keep in mind other types of projects as well, projects in the energy sector like hydroelectric projects, wind energy, and also large agro-industrial operations as well. In many countries in Latin America and Southeast Asia, you have palm oil operations in which you see the similar kinds of dynamics and the similar kinds of discourses on behalf of the governments promoting them and the responses by indigenous peoples. So this conflict, we can appreciate then as part of our work and in receiving these complaints, that the conflict generated due to the high global demand and the high level importance placed by governments on extractive industries, responding again, to the high level of demand, and as well as to the companies, private companies that approach governments and propose these. And as has been pointed out by the previous speakers, governments respond to that as a lure. It lures them into thinking that that's the way out to development, to get out of poverty. In recent decades, these conflicts have become more visible as affected local indigenous peoples, particularly indigenous peoples have become more vocal or outspoken and have become more effective in articulating and demanding the recognition of their rights within national and international forums. In the past 2 decades or so in Latin America, you see that with the growing intensification of extractive industry concessions and operations in indigenous territories, you also have seen on another front, and this has been already pointed out by our previous speakers, these dual forces coming into play in Latin America. But in another front, then you see a growing recognition of indigenous people's rights within constitutional reforms in Colombia, Peru, Guatemala, but most importantly in Bolivia and Ecuador. These last two being considered, on paper and theory, as the most advanced constitutions worldwide. We should also keep in mind the important advances internationally. The ratification of the International Labor Organization Convention 169 on Indigenous and Tribal Peoples, ILO 169, which has been ratified by the vast majority of Latin American countries, and which is the only international treaty on the subject matter and is legally binding on those ratifying countries, including Ecuador, most of the Latin American countries. In many countries, as Daniela has pointed out, international treaties hold a status equal to national constitutional protections, or at least have a status higher than domestic legislation but lower than the constitutions. For sure, though, because of that status that the ILO has, and as Daniela has pointed out, then because of that, indigenous peoples have been very vocal and have demanded the direct application of the ILO 169, as is the main banner, so to speak, of indigenous peoples throughout Latin America. And I know that ILO 169 has actually been the cause for many of the constitutional reforms in Colombia, Ecuador. In Ecuador in '98, since then, has been a major, the building block from which these reforms have come in terms of indigenous rights. In addition, you see that most of the Latin American countries, along with most of the countries of the world, voted in favor of the adoption of the United Nations Declaration on the Rights of Indigenous Peoples by the UN General Assembly in 2007. While this is not a binding treaty, it is definitely an authoritative source for legal interpretation, both of national and international norms of the human rights of indigenous peoples. And Bolivia is the only country, notably, that has adopted this declaration entirely as part of its internal legal system. And the declaration has served as a basis of interpretation by national and international courts, most notably Belize and Colombia, their respective constitutional courts. Of particular importance as well is the development of very advanced jurisprudence within the Inter-American Commission and Court of Human Rights. So here I was just going to include a list here of these indigenous rights sources that I've been talking about, the ILO 169, the Declaration, and an important jurisprudence, some of it that has been already been mentioned by Daniela Salazar, important cases, among them the Mayagna Sumo Community of Awastigni versus Nicaragua case, which is the first international tribunal decision ever to recognize collective land rights. And you have cases out of Paraguay talking about basically the right of indigenous peoples to the restitution of lands that they have lost involuntarily, and sets out standards there. And of course, we have consultation and land rights addressed by the last two important Inter-American court decisions coming out of the Suriname and the Sarayaku case in Ecuador. So the following is just a sampling of the relevant provisions of the ILO 169, and these are the rights by which indigenous peoples of the region are reclaiming their land rights. So basically you have here in these types of international instruments a recognition of the traditional occupation by indigenous peoples of their lands. The countries then that ratify this are committed then, or are obligated to safeguard the right of indigenous peoples to use to not only the lands they occupy, but those lands not exclusively occupied by them, but to which they have traditional access for subsistence and traditional activities, particular attention being paid to nomadic peoples and similar to the ones that you have been mentioned here. And of course, then there's a responsibility of governments to take steps as necessary to identify the lands and recognize them. You see in the Declaration on the Rights of Indigenous Peoples, Article 25, talking about recognizing the distinctive relationship of indigenous peoples with their lands and to their traditional territories. So these legal norms, these international norms are, they strengthen already existing fundamental human rights that exist in other treaties. But what they do is they help contextualize it in the situation of indigenous peoples. So you see here the language of special spiritual relationship, the traditional use of these lands. And so, as you have here, then to the lands, territories, and resources which they have traditionally owned, occupied, and used, and give legal recognition. Again, that obligation by states to provide the legal recognition in accordance with the customs, traditions, and land tenure systems of the indigenous peoples concerned. So you have here a particular focus on what the land means to indigenous peoples. You have then important standards as a duty to consult. Article 6.1 of the ILO Convention 169, perhaps the most cited in the region when it comes to this discourse on the right to consultation, where it talks about, basically lays out the duty of states to consult with indigenous peoples with regards to any measures that affect them, legislative or administrative measures, and lays out that these consultations shall be undertaken in good faith and in a form appropriate to the circumstances, with the objective of achieving agreement or consent. And so in previous reports of the Special Rapporteur, we have indicated that this duty is corollary of universally accepted human rights, including cultural integrity, equality, and right to property and self-determination. Similarly, in the Declaration, you have, again, the same standard, talking about adequate consultation with indigenous peoples, with their representative institutions, with the objective of obtaining their free, prior, and informed consent. So that's a standard that is clear within international standards. In fact, the Declaration sets it out as an obligation. Free, prior, and informed consent is an obligation in certain cases, most notably where the indigenous peoples concerned are going to be relocated. So there shall be no relocation without that free, prior, and informed consent. Let's back up a little bit here. So while you see in Latin America the governments have been willing to ratify ILO 169, vote in favor of the Declaration on Indigenous Peoples, and enact important constitutional reforms, there are serious problems in the implementation of indigenous rights, mainly due to the lack of political will to enact the necessary administrative, institutional changes necessary, as well as due to ongoing attitudes or entrenched discrimination against indigenous peoples within the legal and political cultures in many countries. In the rapporteurship and in the legal support team of the rapporteur, we have seen that despite the wide acceptance, for example, of a duty to consult with indigenous peoples regarding all measures that affect them, that there is a serious disagreement between governments and indigenous peoples and other civil society sectors as to the content and extent of the principle of free, prior, and informed consent, and whether this right provides the right of one segment of the population, in this case the indigenous peoples, to basically veto the development agenda of a nation. By implication, then, whether respecting the rights of these peoples would affect the right of a whole nation's development. So this has been a point that has been consistently coming up in the cases that have been brought before the Special Rapporteur, and in which the Special Rapporteur in his various reports, thematic reports on the issue of extractive industries and consultation, has insisted on framing the discussion beyond that of whether a power of veto exists, because that was not the intent of these international instruments. As he points out in these reports, these principles, these rights, were meant to revert previous patterns of government action that severely impacted indigenous human rights without their participation and inclusion into decision-making processes that impact their lives. It was meant to prevent unilateral actions by governments and third parties that could seriously affect their lands, resources, cultures, and identities as a people. In recent thematic reports, the rapporteur has proposed that governments and other interested parties, including indigenous peoples, other peoples interested in the matter, to address the issue that come up in the context of extractive industries and indigenous peoples, not on this issue of whether consultation is even a standalone right or whether there's a veto power or not, but to again focus on what are the substantive rights that are affected by a particular operation. In this, paying attention again to the substantive rights recognized in these instruments, recognized by general human rights treaties treaties adopted by all parties, including Ecuador and other Latin American countries, in terms of the respect for culture, property, and the right to be free from discrimination. And so to see what are the rights at play and in which consultation and consent then come in only as safeguards to those rights. So what follows here is just an extracts or excerpts of the recent reports by the Rapporteur, in which he's trying to point out this change, this reference that's needed, this point of reference that we need to keep in mind when talking about extractive industries and consultation. And again, as I pointed out earlier, it's a requirement, of consultation and consult as being a function of the substantive rights implicated. If the substantive rights of a particular indigenous peoples are essential to the survival of indigenous groups as distinct peoples, and the foreseen impacts on the exercise of those rights is significant, then consent, free, prior, informed consent, is required beyond being the objective of consultation. So these are interpretations done of the different instruments that I pointed out, of the different jurisprudence that previous speakers have already alluded to here. So the rights to traditional lands and resources, including those recognized or not recognized but customarily used, are generally understood to be those that are essential to survival, and in which consent would be then a requirement for that proposed measure. If consent is obtained, and if it is obtained, it should be upon equitable and agreed upon terms, including terms for compensation, mitigation measures, and benefit sharing. So consent, again, the requirement is that that consent is obtained through a good faith dialogue, right? In the most recent report in 2013, there's certain interesting points being made here that they build on what was previously said on the substantive rights of indigenous peoples. There's an interesting discussion there of indigenous peoples' rights to oppose extractive activities as part of their firmly established right to freedom of expression without fear of reprisals and violence, that being a major cause of human rights violations across the world, in Latin America and other areas, is when indigenous peoples express themselves against a particular project, then you have, it generates ongoing human rights violations. States should not insist or allow companies to insist that indigenous peoples engage in consultations on proposed activities to which they have clearly expressed opposition. This is a very complex matter, but it has come up where indigenous, and this usually comes up when, and this has already been brought up as a problem, when the state decides to consult, mostly in cases where it already has made the decision, a project has already started, but then because of popular pressure, then there's a desire to do things right this time. However, but even then, you have seen projects when, from the get-go, indigenous people say, this is not even for discussion. We don't want to even consult. You don't need to consult with us. We do not want this, period. What happens with that? Whatever. When states make efforts to consult about the projects and the indigenous peoples oppose it, and they oppose it in principle as a recognition of their self-determination rights, the state's obligations to consult is discharged, right? But the question becomes, what happens after that? This kind of scenario then has the same effect as when, after you've done an actual consultation, what happens when the indigenous peoples withdraw or there's no consent, they withdraw their consent. So then there has to be an action in accordance with international standards. I think I don't know how I'm doing with time here, but this is some of the most important analysis in the Rapporteur's report here, and I think has already been included in some of the jurisprudence that Daniela Salazar has pointed out, and much of the inter-American jurisprudence, is that we need to see that if you're going to have exceptions to activities that affect indigenous people's rights without the consent, you need to apply certain human rights standards on the limitation of those rights. Basically, under international human rights law precepts, for a limitation to be valid, it has to be necessary and proportional in relation to a valid state objective. You have here in the inter-American jurisprudence, in fact, in the case of Saramaca, you say, well, property rights are not absolute and they can be affected. However, to restrict those rights, it's only permissible if they meet the criteria of necessity and proportionality in relation to a valid public purpose. And among those actions that meet that criteria is consultation and consent. Basically, in Saramaca is a well-known case for developing that principles of consultation, the right of indigenous peoples to the obligation of impact statements, of environmental social impact statements, and it's for future reference. In analyzing a state's intent to expropriate indigenous land and natural resources to allow activities, even if just compensation is provided, an important threshold question is whether the limitation is pursuant to a valid public purpose. And so in the report, there is a statement there that the rapporteur has cautioned, brings to light. I mean, if a valid purpose is found in mere commercial interest, or where the interest or the benefits are primarily for private gain, are those, just and proportional necessary interests that are at play here? Are those worth violating fundamental human rights of an indigenous peoples for, basically? The limitation must be necessary and proportional, as we said. Due account, to determine that necessity and proportionality, due account must be taken of the significance of the range of rights potentially impacted for the if it affects the survival of indigenous peoples. Again, the substantive rights of indigenous peoples to life, culture, property, non-discrimination. Account shall be taken of the fact, and this is another issue that comes up, that indigenous peoples, maybe under their own customary norms, consider that all resources, or actually even the ones in the subsurface, belong to them, or they should have the rights to them. And this goes contrary to a lot of state precepts that say that the resources, even in private property, the resources belong to the state. So there's sort of an advocating of a position here that will also keep in mind what indigenous people's own laws and customs are regarding those resources. So again, this is a threshold, a test, so to speak, as to how extractive industries could proceed, if at all, if these requirements are met. So, as you can see, there certain factors weigh heavily against finding of proportionality of state-imposed rights limitations. So it reinforces the need of a free, prior, and informed consent to those. Okay. One point that is also advocated in the report is the need for judicial review of those decisions taken by the states against the consent of an indigenous peoples. There should be judicial review of that decision and whether the state met its burden of justifying any limitations on those rights. For their parts, the company should conduct due diligence before proceeding with extractive operations without the prior consent of the concerned indigenous peoples, and conduct their own independent assessment of whether or not the operations are in compliance with international standards. So this concept that companies too have international obligations derived from the United Nations Guiding Principles in Business and Human Rights. One of the main pillars in this framework for the respective indigenous rights is the concept of due diligence, as you can read here. Due diligence that companies must take to avoid violations of human rights. And again, those guiding principles also point out that companies need to apply whatever legal regime, depending on what population you're talking about. So in the case of indigenous peoples, the companies need to keep in mind ILO 169, the Declaration of Other Standards on Indigenous Rights. And so that's the end of the PowerPoint. So again, another thing to keep in mind, I don't know if Daniela, you mentioned it, are the Office of the High Commissioner of Human Rights issued these guidelines for the protection of indigenous peoples in isolation and initial contact. These were guidelines that were adopted in 2012 with the participation of government representatives and an initiative of the local Office of High Commissioner office there, the United Nations. So they too talk about important principles to keep in mind, the principle of no contact, and for all decisions of the state to consider the vulnerability of the indigenous populations in isolation, and what human rights effects it has on them due to their particular vulnerabilities.
Thank you very much.